Hi friends, this is Naganand. I am going to dictate a passage at 80 words per minute for 5 minutes. 5 seconds left. Start. The petitioner contended before the Labour Court that only one passenger boarded the bus at stage number 22. The said passenger deliberately deceived the petitioner and reported to him that he had already purchased the ticket. It is maintained by the petitioner that when the check was effected, the said passenger, however, in fear of penal consequences, falsely told the checking officials that despite his paying the requisite fare, he was not given ticket by the petitioner. This statement was disbelieved both by the inquiry officer and also by the Labour Court. The Labour Court has observed that the petitioner has failed to raise any objection when the spot statements were obtained from the passengers and that in fact he attested them. Accordingly, the Labour Court has concluded that having not disputed the statement of the passengers when they were obtained, the petitioner could not further raise any objection about the veracity of the statements. Undeniably, the spot statements of the passengers were recorded in the petitioner's presence. Indeed, the petitioner did attest the said statement. It is, however, not correct to say that having attested the said statements given by the passengers, the petitioner is stopped from controverting the veracity of the statements issued by the passengers. The attesting of the statements of the passengers by the conductor, if at all, only amounts to an acknowledgement of the fact that those statements were recorded in his presence. In any event, the contents of those statements do not bind the delinquent conductor simply on the premise that he attested them. Accordingly, the observation of the Labour Court that the petitioner did not record his objection on Exhibit M3, the passenger's statement doesn't pass the judicial muster. The petitioner has also taken the plea that though he asked the TTs to count the cash in his bag to find out whether the petitioner actually collected any excess amount without issuing any ticket, but the said officials refused to do so. On this point, the Labour Court has observed that the petitioner has failed to raise any objection on the said issue. It is further held that only in the course of disciplinary proceedings the petitioner took the said plea by filing his written statement Exhibit M9 dated 3/4/2006, that is about 2 months after the spot inspection. Given the expansive scope of 11A of the Act, this observation on the part of the Labour Court cannot be countenanced. notwithstanding the fact that the petitioner raised the objection to the course of departmental inquiry. Stop.